Hello all. Let us continue with the characteristics of the company. The second point is company as an artificial person. A company is an artificial person created by law. It is not a human being, but it acts through human beings. It is considered as a legal person who can enter into contracts, possess properties in its own name, sue, and can be sued by others, etc. It is called an artificial person since it is invisible, intangible, existing only in the contemplation of law. It is capable of enjoying rights and being subject to duties. The next is a case example that is given. Union Bank of India versus Kadar International Construction and others. 2001 42 CLA 296 SC. In this case, the question which arose before the court was whether a company is entitled to sue as an indigent, that is poor person, under Order 33, Rule 1 of the Civil Procedure Code 1908. The aforesaid order permits persons to file suits under the code as pauper or indigent persons if they are unable to bear the cost of litigation. The appellant in this case had objected to the contention of the company which had sought permission to sue as an indigent person. The point of contention was that the appellant being a public limited company, it was not a person with the purview of Order 33, Rule 1 of the Code, and the person referred to only a natural person and not to other juristic persons. The Supreme Court held that the word person mentioned in Order 33, Rule 1 of the Civil Procedure Code 1908 included any company as association or body of individuals, whether incorporated or not. The court observed that the word person had to be given its meaning in the context in which it was used, and being a benevolent provision, it was to be given an extended meaning. Thus, a company may also file a suit as an indigent person. The third characteristic is company is not a citizen. The company, though a legal person, is not a citizen under the Citizenship Act 1955 or the Constitution of India. In State Trading Corporation of India Limited versus CTO AIR 1963 SC 1811, the Supreme Court held that the State Trading Corporation, though a legal person, was not a citizen and can act only through natural persons. Nevertheless, it is to be noted that certain fundamental rights enshrined in the Constitution for protection of person, for example, right to equality under Article 14, etc., are also available to company. Section 2, subsection F of Citizenship Act 1955 expressly excludes a company or association or body of individuals from citizenship. Next is a case example that is given in R.C. Cooper versus Union of India AIR 1970 SC 564. In this case, the Supreme Court held that where the legislative measures directly touch the company of which the petitioner is a shareholder, he can petition on behalf of the company if by the impugned action his rights are also infringed. In that case, the court entertained the petition under Article 32 of the Constitution at the instance of a director as shareholder of a company and granted relief. It is therefore to be noted that an individual's right is not lost by reason of the fact that he is a shareholder of the company. We have one more case example that is given. Bennett Coleman Company versus Union of India AIR 1973 SC 106. In this case, the Supreme Court stated that it is now clear that the fundamental rights of shareholders as citizens are not lost when they associate to form a company. When their fundamental rights as shareholders are impaired by state action, their rights as shareholders are protected. The reason is that the shareholders' rights are equally and necessarily affected if the rights of the company are affected. The fourth characteristic is company has nationality and residence. Though it is established through judicial decisions that a company cannot be a citizen, yet it has nationality, domicile and residence. In Gaskew versus Inland Revenue Commissioners 1940 2 KB 88, McNaughton J. held that a limited company is capable of having a domicile and its domicile is the place of its registration and that domicile clings to it throughout its existence. He observed in this case, it was suggested that a body corporate has no domicile. It is quite true that a body corporate cannot have a domicile in the same sense as an individual. But by analogy with a natural person, the attributes of residence, domicile and nationality can be given to a body corporate. The next case that is given is in Tulika versus Parry and Company 1903, Kelly C.B. observed, a joint stock company resides where its place of incorporation is, where the meetings of the whole company or those who represent it are held, and where its governing body meets in bodily presence for the purposes of the company and exercises the powers conferred upon it by statute and by the Articles of Association. The fifth characteristic is limited liability. The privilege of limited liability for business debts is one of the principal advantages of doing business under the corporate form of organization. The company, being a separate person, is the owner of its assets and bound by its liabilities. The liability of a member as shareholder extends to the contribution to the capital of the company up to the nominal value of the shares held and not paid by him. Members, even as whole, are neither the owners of the company's undertakings nor liable for its debts. In other words, a shareholder is liable to pay the balance, if any, due to the shares held by him when called upon to pay and nothing more, even if the liabilities of the company far exceed its assets. This means that the liability of a member is limited. For example, if A holds shares of the total nominal value of 1000 and has already paid 500 rupees or 50% of the value as part payment at the time of allotment, he cannot be called upon to pay more than 500 rupees, the amount remaining unpaid on his shares. If he holds fully paid shares, he has no further liability to pay even if the company is declared insolvent. In the case of a company limited by guarantee, the liability of members is limited to a specified amount of the guarantee mentioned in the memorandum. Buckley J. in reply to London and Globe Finance Corporation observed that the statutes relating to limited liability have probably done more than any legislation of the last 50 years to further the commercial prosperity of the country. They have, to the advantage of the investor as well as of the public, allowed and encouraged aggregation of small sums into large capitals which have been employed in the undertakings of great public utility, largely increasing the wealth of the country. Exceptions to the principle of limited liability. Members are severally liable in certain cases. If at any time the number of members of a company is reduced, in the case of public company below 7, in the case of private company below 2, and the company carries on business for more than 6 months, while the number of members is so reduced, every person who is a member of the company during the time that it so carries on business after those 6 months and is cognizant of the fact that it is carrying on business with less than 7 members or 2 members, as the case may be, shall be severally liable for the payment of the whole debts of the company contracted during that time and may be severally sued thereof. That is section 3A. Second, when the company is incorporated as an unlimited company under section 3, subsection 2, clause C of the Act. 3. Where a company has been got incorporated by furnishing any false or incorrect information or representation or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company or by any fraudulent action, the tribunal may, on an application made to it, on being satisfied that the situation so warrants, direct that liability of the members of such company shall be unlimited. This is mentioned in section 7, subsection 7, clause B. Further, under section 339, subsection 1, where in the course of winding up it appears that any business of the company has been carried on with an intent to defraud creditors of the company or any other persons or for any fraudulent purpose, the tribunal may declare the persons who were knowingly parties to the carrying on of the business in the manner aforesaid as personally liable without limitation of liability for all or any of the debts or liabilities of the company. The next is under section 35, subsection 3, where it is proved that a prospectus has been issued with intent to defraud the applicants for the securities of a company or any other person or for any fraudulent purpose. Every person who was a director at the time of issue of the prospectus or has been named as a director in the prospectus, or every person who has authorized the issue of prospectus, or every promoter or a person referred to as an expert in the prospectus shall be personally responsible without any limitation of liability for all or any of the losses or damages that may have incurred by any person who subscribed to the securities on the basis of such prospectus. Next is as per section 75 subsection 1, where a company fails to repay the deposit or part thereof or any interest thereon referred to in section 74 within the time specified or such further time as may be allowed by the tribunal, and it is proved that the deposits had been accepted with intent to defraud the depositors or for any fraudulent purpose, every officer of the company who was responsible for the acceptance of such deposit shall, without prejudice to other liabilities, also be personally responsible without any limitation of liability for all or any of the losses or damages that may have been incurred by the depositors. And the last point is section 224 subsection 5 states that where the report made by an inspector states that fraud has taken place in a company and due to such fraud any director, key managerial personnel, other officers of the company or any other person or entity has taken undue advantage or benefit, whether in the form of any asset, property or cash or in any other manner, the central government may file an application before the tribunal for appropriate orders with regard to disgorgement of such asset, property or cash, and also for holding such director, key managerial person, officer or other person liable personally without any limitation of liability. The sixth characteristic is perpetual succession. An incorporated company never dies except when it is wound up as per law. A company being a separate legal person is unaffected by death or departure of any member, and it remains the same entity despite total change in the membership. Perpetual succession means that the membership of a company may keep changing from time to time, but that shall not affect its continuity. The membership of an incorporated company may change either because one shareholder has sold or transferred his shares to another, or his shares devolve on his legal representatives on his death, or he ceases to be a member under some other provisions of the Companies Act. Thus, perpetual succession denotes the ability of a company to remain or maintain its existence by the succession of new individuals who step into the shoes of those who cease to be members of the company. Professor L.C.B. Gower rightly mentions, members may come and go, but the company can go on forever. During the war, all the members of one private company, while in general meeting, were killed by a bomb, but the company survived. Not even a hydrogen bomb could have destroyed it. The seventh characteristic is separate property. A company, being a legal person and entirely distinct from its members, is capable of owning, enjoying and disposing of property in its own name. The company is the real person in which all its property is vested and by which it is controlled, managed and disposed of. The Lordship of the Madras High Court in R.F. Perumal versus H. John Devon held that no matter can claim himself to be the owner of the company's property during its existence or in its winding up. A member does not even have an insurable interest in the property of the company. A case example of Mrs. Bacha F. Gustar versus the Commissioner of Income Tax Bombay is given. The Supreme Court in this case held that though the income of a tea company is entitled to be exempted from the income tax up to 60% being partly agricultural, the same income when received by a shareholder in the form of dividend cannot be regarded as agricultural income for the assessment of income tax. It was also observed by the Supreme Court that a shareholder does not, as is erroneously believed by some people, become the part owner of the company or its property. He is only given certain rights by law, that is to receive notice of or to attend or vote at the meeting of the shareholders. The court refused to identify the shareholders with the company and reiterated the distinct personality of the company. Transferability of shares. The capital of a company is divided into parts called shares. The shares are said to be movable property and subject to certain conditions, freely transferable, so that no shareholder is permanently or necessarily wedded to a company. When the joint stock companies were established, the object was that their shares should be capable of easily being transferred. Section 44 of the Companies Act 2013 enunciates the principle by providing that the shares held by the members are movable property and can be transferred from one person to another in the manner provided by the articles. If the articles do not provide anything for the transfer of shares and the regulations contained in Table F in Schedule 1 to the Companies Act 2013 are also expressly excluded, the transfer of shares will be governed by the general law relating to transfer of movable property. A member may sell his shares in the open market and realize the money invested by him. This provides liquidity to a member, that is, as he can freely sell his shares, and ensure stability to the company as the member is not withdrawing his money from the company. The stock exchanges provide adequate facilities for the sale and purchase of shares. Further, as of now, in most of the listed companies, the shares are also transferable through electronic mode, that is through depository participants in dematerialized form instead of physical shares. However, there are restrictions with respect to transferability of shares of a private company. Even if a share of a private limited company is in demat form, restrictions by the articles of the company shall apply. The ninth point is capacity to sue and be sued. A company being a body corporate can sue and be sued in its own name. To sue means to institute legal proceedings against a person or to bring a suit in a court of law. All legal proceedings against the company are to be instituted in its name. Similarly, the company may bring an action against anyone in its own name. A company's right to sue arises when some loss is caused to the company, that is to the property or the personality of the company. Hence, the company is entitled to sue for damages in libel or slander as the case may be. Floating Services Limited versus MN San Francisco de Palova. A company as a person distinct from its members may sue one of its own members also. A company has a right to seek damages where a defamatory material published about it affects its business. Where video cassettes were prepared by the workmen of a company showing their struggle against the company's management, it was held to be not actionable unless shown that the contents of the cassette would be defamatory. The court did not restrain the exhibition of the cassette. That is TVS Employees Federation versus TVS and Sons Limited. The company is not liable for contempt committed by its officer. That is Lalit Surajmal Kanodia versus Officer Tiger Database Systems Private Limited. The 10th is the contractual rights. A company being a legal entity different from its members can enter into contracts for the conduct of the business in its own name. A shareholder cannot enforce a contract made by his company. He is neither a party to the contract nor be entitled to the benefit derived from it, as a company is not a trustee for its shareholders. Likewise, a shareholder cannot be sued on contracts made by his company. The distinctions between a company and its member is not confined to the rules of privity but permeates the whole law of contract. Thus, if a director fails to disclose a breach of his duties towards his company and in consequence a shareholder is induced to enter into a contract with the director on behalf of the company which he would have entered into had there been disclosure, the shareholder cannot resign the contract. Similarly, a member of a company cannot sue in respect of torts committed against the company, nor can be sued for torts committed by the company. Therefore, the company as a legal person can take action to enforce its legal rights or be sued for breach of its legal duties. Its rights and duties are distinct from those of its constituent members. The 11th point is limitation of action. A company cannot go beyond the power stated in its Memorandum of Association. The Memorandum of Association of the company regulates the powers and fixes the objects of the company and provides the edifice upon which the entire structure of the company rests. The actions and objects of the company are limited within the scope of its Memorandum of Association. In order to enable it to carry out its actions without such restrictions and limitations in most cases, sufficient powers are granted in the Memorandum of Association. But once the powers have been laid down, it cannot go beyond such powers unless the Memorandum of Association itself is altered prior to doing so. The next point is separate management. As already noted, the members may derive profits without being burdened with the management of the company. They do not have effective and intimate control over its working, and they elect their representatives as directors on the board of directors of the company to conduct corporate functions through managerial personnel employed by them. In other words, the company is administered and managed by its managerial personnel. The next point is voluntary association for profit. A company is a voluntary association for profit. It is formed for the accomplishment of some stated goals, and whatsoever profit is gained is divided among its shareholders or saved for the future expansion of the company. Only a Section 8 company can be formed with no profit motive. The last point is termination of existence. A company, being an artificial juridical person, does not die a natural death. It is created by law, carries on its affairs according to law throughout its life, and ultimately is affected by law. Generally, the existence of a company is terminated by means of winding up. However, to avoid winding up, sometimes companies adopt strategies like reorganization, reconstruction, and amalgamation. To sum up, a company is a voluntary association for profit with capital divisible into transferable shares with limited liability, having a distinct corporate entity and a common seal with perpetual succession. With this, we come to the end of the characteristics of a company. The next topic is company with comparison to other forms of a company, that we will see in the next video. Thank you. Take care, stay safe, and stay tuned.